Australian law is a complex and diverse system that regulates various aspects of life in Australia. It consists of different types of laws, such as statutes or codified laws. These are laws that are enacted by state and federal parliaments after a debate. They can only be changed by Parliament. For example, the Constitution of Australia is the supreme law of the country that establishes the federal system of government and the rights and responsibilities of the citizens. 1. Common law or uncodified law. These are laws that are derived from the decisions of judges in the court system. They are based on the principles of precedent, equity, and justice. They can be changed by new legislation or judicial interpretation. For example, the law of negligence is a common law doctrine that imposes a duty of care on people to avoid causing harm to others. 2. Customary law. These are laws that are based on the traditions and customs of Indigenous Australians. They vary between language groups, clans, and regions. They are often intertwined with cultural practices, stories, and beliefs. They have been largely ignored by the colonial and post-colonial legal system, but have been recognized to some extent by Australian courts in recent years. For example, native title is a form of land rights that recognizes the connection between Indigenous Australians and their ancestral lands. 23. Australian law also incorporates international law, such as treaties, conventions, and agreements that Australia has signed or ratified with other countries or organizations. These can affect the interpretation and application of domestic laws in certain areas, such as human rights, trade, and environmental protection.